Hello, my name's Olurotimi Osha. I like talking about American presidents, and today I want to discuss an instance when a president exercised quote unquote dictatorial powers through his use of emergency powers. So, again, emergency powers are constitutional, it's in our constitution. We saw how Abraham Lincoln used emergency powers to suspend habeas corpus during the Civil War. And of course, Franklin Delano Roosevelt, he also exercised these emergency powers, which are actually dictatorial, um, during the Second World War. After the Empire of Japan, you know, used through airstrikes, attacked America's military base at Pearl Harbor in Hawaii. This was December 7, 1941. 4 days after the Axis powers, Germany and Italy declared war on the U.S. Of course, the U.S. declared war immediately after Japan attacked the United States at Pearl Harbor. The next day, that's December the 8th, 1941. Subsequently, Franklin Delano Roosevelt issued Executive Order 9066. This was in February 1942. Of course, this led to the internment uh, of about 122,000 Japanese Americans, right? Many of whom, most of whom were actually loyal to the United States. Many of them, most of them were United States citizens, but they were moved into these concentration camps on the West Coast following this executive order, which authorized military commanders, including Lieutenant General DeWitt, to issue proclamation orders that created exclusion zones, right? Exclusion zones. Now, after uh, after FDR issued his executive order 1966, today, it's been over 70 years, in fact, over 80 years since that time. The significant actors that we've revisited, the significant actions we've revisited over and over, at least for me, as a graduate of law school in the US, have been the cases that came about as a result of that executive order, and the constitutionality, the abuse of the rights of Japanese Americans. Korematsu is very, very popular. Korematsu versus the United States. And there's also what one of the justices, Hugo Black, called its precedent. In fact, most of the justices on the Supreme Court, um, most of them claimed that Hirabayashi, that's Gordon Hirabayashi, that was a similar case, was precedent for Korematsu. So it's the cases that came about, and the actions of the justices, because remember I said, well, the president does have emergency powers, right? In times of war is an emergency, and so the idea of an emergency power of the president is to be able to take decisive action, because the legislative process, the people, the body that makes legislation, makes laws for the country, it's Congress, and it's a very slow process in times of emergency like a war, even during COVID. So our constitution grants the executive, the president, to make quick decisions, decisive decisions, and everything. But it doesn't, and these are dictatorial. So these might tend to violate our rights, but we still have guardrails, right? And one of those guardrails is there's judicial oversight, right? So these emergency orders are still subject to judicial review, right? The justices, the judiciary can check the constitutionality of those laws. For instance, we saw what happened in during the Civil War, in the case of Lambden P. Milligan, who was, with the under the Habeas Corpus Suspension Act, was tried in a military tribunal and sentenced to death. And there was a ex parte, the case went all the way to, it was appealed all the way to the Supreme Court and ex parte Milligan. And the Supreme Court said, it was the Chief Justice then was Salmon P. Chase. The Supreme Court said, well, that this is unconstitutional because you can't have martial law, or you can't have, citizens can't be subjected to trial by military tribunal when civil courts are open and operational, so that the conviction of Milligan was voided and ruled unconstitutional. So, however, we find that in the case of Korematsu and Hirabayashi, the justices failed so much so that we continue to study and these cases, the opinions of these justices. The decision in Korematsu has been called today a stain on American jurisprudence. They've called it an odious. What was it called? An odious artifact uh, of popular bigotry, something of the sort. So they've called it all sorts of names, that it's anti-canon, it's anti-canonical. When they say something is anti-canonical, anti-canon, an anti-canon case is, a case cannot be, that's cited as an example of an unconstitutional law, a law that's not constitutional, right? A very badly reasoned case. It's not constitutional. Cases, for instance, that are called anti-canon are, I've normally cited, raised Dred Scott, the Dred Scott decision, the dreadful Dred Scott decision. That's Dred Scott versus Sanford, right? As Plessy versus Ferguson. So Korematsu is up there. Korematsu versus the United States is up there as an anti-canon law. However, so Fred Korematsu, he was a young Japanese American. He was convicted for violating those orders. The orders to go into an internment, a Japanese internment, a concentration camp in 1944, when he eventually went all the way to the Supreme Court. But since then, right, the case has been overturned, and Hirabayashi's as well, since in the 1980s they were overturned. And in fact, there's Congress passed what's called, was it Congress or the president, there's the Civil Liberties Act of 1988, in which Japanese survivors of the internment of the Japanese American concentration camps during the Second World War were paid $20,000, right? Each survivor that still remained as of 1988, they were paid $20,000. So there has been reparations that have been paid in America as well, except only African Americans have not received reparations, for slavery and other injustices. But anyway, so reparations were paid in 1988 with the Civil Liberties Act of 1988 to the survivors of the concentration, the internment camps of the internment of Japanese during the Second World War. Now, it's interesting. I want to go into the cases because I have a law degree, and this is very significant to me. But I'm going to give the backstory, the background, and what sort of makes it very unconstitutional. Interestingly, I've talked about judicial review in the past, right? There's standards. There are things that are called standards of review, by the courts, right? So the judiciary, they interpret the laws, the Constitution. They make sure that things are constitutional. That laws, decisions by the government are constitutional. Remember, our government is broken into the executive. They enforce the law. The legislature, it's Congress. They make the laws, and then there's a judiciary. They interpret the law, right? They interpret the law. The judiciary, they do not have a military. They don't have a military behind them, or cops behind them to enforce laws, right? So it's interesting that in fact the dissenting opinions in Korematsu there were three justices who dissented in Korematsu. Uh, there was Owen Roberts, there was Robert Jackson, and Justice Murphy. Three of them dissented, and one of them, I think it was Justice Jackson. Justice Jackson, what he wrote was brilliant. It's bliss. I would like to actually discuss, the way their opinions, later on. I'll do a subsequent video, but something he noted was that look, um, the majority, right? Hugo Black was one who wrote, Justice Hugo Black was one who wrote the opinion. The majority said, well, that this was this law, right? The law that excluded Japanese and put them in this mass imprisonment in concentration camps were a military expedient, and it's the military that sort of have to make these decisions to be able to prevent espionage and sabotage and to be able to win the war, right? So it's part of the law. They're saying it was constitutional, right? That's what the majority, Hugo Black, that's what they said, right? And in fact, it's interesting that Hugo Black said, well, that in fact this is not based on, it's not based on race. It's not based on animus towards the Japanese ancestry, right? That's legal legerdemain, right? It's just legal trickery, right? So the fact that you're saying something is not what it is does not mean that it's true. That's exactly what the justice was doing there. He was just saying, well, what was clearly and everybody sees as racism, he thinks by just saying it's not racism that it makes it true that it's not racism. So I'll get into it later on, get into the cases and analysis later on. I just want to give a broad overview. But importantly, Robert Jackson retorts saying that, look, well, it's the court has its role, right? Yes, there's martial law, but the court has its role in making sure that things that are a law that's a military expedient, you don't make it universally applicable, and you don't make it law for all times. You don't make it precedent. Precedent is the word I'm looking for. You don't make it precedent with the court having to ratify it. The court doesn't have to ratify it and say, well, this is actually constitutional, right? But there was something he raised. He pointed out that, but even if the court were to say that, well, this is not, this is unconstitutional, they have no means to enforce that law, because the military, it's a war. The military, the executive is going to do what they want to do anyway, and the courts don't have the means to enforce their opinion if they say, well, this is unconstitutional. And we see this happened during the era of Andrew Jackson, right? In the time of the Indian Removal Act, in the case Worcester versus Georgia, right? And the Supreme Court acknowledged the sovereignty of Native Americans, right? But Andrew Jackson refused to obey it, right? He still did the Indian Removal Act. He said, well, Chief Justice Marshall has made his decision, and, cheekily, right, sarcastically, he said, let him enforce it, tongue in cheek, knowing that the Chief Justice, the Supreme Court, has no way of enforcing its laws. What it says, well, this is the Constitution. So this is something that Justice Robert Jackson was pointing out, that the fact that there's a military expedient, it doesn't mean that the Supreme Court has to sanction it and say something that's clearly a constitutional violation is constitutional and set a bad precedent, right? And this was the bad thing that the Supreme Court, the Chief Justice then was Harlan Fiske Stone. This was a bad precedent that they tried to set. They tried to say, well, that the internment of Japanese Americans in concentration camps and the executive order and the subsequent proclamations, that it was constitutional, right? And he said, that it was not based on racism, when it clearly was based on the ancestry of Japanese Americans, right? Because we see the U.S. was in war with German Americans. The U.S. was at war with Italian Americans. Now, Lieutenant General DeWitt, right, who was the commander of the Western Defense Command, at the time, he issued, some of these proclamations. Was it Civilian Exclusion Act proclamation, or number 34, proclamation number 34, whatever if it was called? I'll check and verify that. But he singled out Japanese Americans to be, ostracized, excluded, and removed and relocated to these concentration camps on the West Coast, right? And while America was at war with with Germany and Italians, German Americans, Italian Americans were not targeted in the same way. Yes, um, there was actually another law that had German Americans interned in concentration camps, but again, this was marginally applied. It was the Alien Enemy Act, right? Alien Enemy Act of 1798. Remember the Alien Seditions Act of 1798 during the quasi-war with France, which the John Adams administration had passed. Now, the Alien Enemy Act was a relic of those laws, because most of the Alien and Sedition Acts, they expired. But the Alien Enemy Act, right, it remains. In fact, I think it's still there till today, but it was still extant in during the Second World War. And so what happened was, about, say about 11,000 German Americans were interned, were placed in a concentration camp. But those were uh, German Americans that had broken a law. So the United States had proscribed, it banned certain organizations, including the German American Alliance Bund, right? It was a Nazi organization, right? It was they were Nazi sympathizers. It was a Nazi organization. It was pro the Nazis. The United States was in a war against Nazi Germany. So these people were actually arrested. They were placed interned because of their affiliation with a proscribed organization, right? A proscribed organization that was in alliance with uh, with an enemy the United States was at war with, right? This was not the case with Japanese Americans that were interned. In fact, the Japanese Americans were all, there was no evidence that there was any disloyalty amongst them, right? So I'll get into the cases and talk about the background, because I see I'm getting into the legal arguments, right? So we see that the laws were, the executive order and the proclamations were, they targeted Japanese Americans clearly because of their race, right? When we talk about race, you're dealing with phenotypes and ancestry, and not specifically, uh, you know, not you're dealing with one's ancestry, right? Phenotype, right? So people of Japanese Americans, right? They are of East Asian ancestry, and they have phenotypes that we associate with their race. For instance, when we're talking about racism against Black Americans, I'm going to use an analogy here. I think it will help. When we're talking about discrimination against Black people, right? It's not because they were descendants of slaves that they're discriminated against, right? I'm not a descendant of slaves, but I experience today the same racism, the same police brutality that Black Americans who are descendants of slaves experience, because we're mutually descendants. We're of African descent. We're descendants of a certain region, right? A certain ancestry. We share that ancestry, right? People of African descent, right? Whether you come from Jamaica, the Caribbeans, or Senegal, so long as we have that, the phenotypes that we share, where we have the African descent, and of course we're Black. We're Black as well. So similar, to the Japanese Americans, right? They were interned, they were targeted, and excluded and placed in these concentration camps because of their Japanese ancestry. So it was disingenuous for Justice Hugo Black, who wrote the opinion, to have said that, well, it wasn't because of race, that they were not placed in the concentration camps or targeted because of their of race or animus towards their race. That was just disingenuous. It was not true. If we notice, and he was citing the authority of the military, that it was just a military expedient, and it was a strategy for them to be able to win the war. Now think about it. America, as one of the justices pointed out, that look, that Americans can trace their ancestry, their blood, their biological, their culture, their relationship to other nations, right? That we have an American experiment and we all come from different places. We can trace our ancestry to and culture to other nations, right? To people of other nations. And this was true at our founding as well, right? So at the time of our founding, the founding fathers were fighting against Britain. But our founding fathers, George Washington, he was British descent. He was Anglo-Saxon. We were fighting against Anglo-Saxons. It was our people, Americans, the founding fathers, early Americans. They're fighting their brethren, right? John Adams was a descendant of English people. He was Anglo-Saxon. George Washington, Alexander Hamilton, he was Scottish descent. He was. These were people who actually had British ancestry, right? We didn't create. There was no emergency power that targeted, that said, well, that people of British descent or Anglo-Saxons, they should be set aside because they might sabotage us, right? In fact, there was division. There was division within the family. Benjamin Franklin's son actually was a loyalist, right? So this is as likely to occur, like sabotage, this descent, this ability to sabotage or espionage. It is likely to occur with anybody who's American as well, right? Just like I said, Benjamin Franklin's son. Benjamin Franklin was a founding father. His son was on the British side. He was a loyalist. He fled to England because he'd been a governor, right? He'd been a royal governor at that time, and he remained loyal. He remained loyal to the crown, and he fled. So there was division within the family. Benedict Arnold, in fact, he was a general on the American side. He betrayed America. So this is likely to occur with anybody, and there was no evidence. There was no evidence specifically that showed that Japanese Americans, right, were spying on behalf of the Japanese Empire, the Empire of Japan. There was no evidence that they were conducting sabotage or spying on their behalf. In fact, there was a report, and I'm going to give the story later. This video is getting long because I've been focusing on the legal analysis, sort of, which is, I enjoy the legal analysis again, being a graduate of law school. There was a report, the Office of Naval Intelligence, the Ringel report. It said that, well, there was no evidence of disloyalty amongst Japanese Americans, right? But the Japanese Americans were cooperative. They moved themselves, the majority of them. But there were some of them who defied the law, like Fred Korematsu. He was a young person who was an American citizen, and he said it violated his Fifth Amendment rights. He used the Fifth Amendment, not the 14th Amendment. Remember, the 14th Amendment, yes, it says there's equal protection, it says due process as well. He used the Fifth Amendment because the Fifth Amendment, it deals with protections against the federal government. The 14th Amendment does not have protections against the federal government. The 14th Amendment projects all the Bill of Rights, including the Fifth Amendment, against the states. So that's why Korematsu, it was the federal government that was violating his rights. So Korematsu had to use the Fifth Amendment, saying that the federal government was violating his due process of law rights. Korematsu, I'm going to do a subsequent video and discuss, the background and what exactly he did. It was very interesting. He really tried to evade the government. He even went to do plastic surgery and he fled. So, but they caught him, and eventually, he was convicted. and there was the decision of Korematsu, which remains today. It's been voided. The law has been voided. It's been abased. It's been deemed anti-canon, an anti-canon case, and things like that. In the 1980s, there was a writ of what's called que coram nobis resident. Que coram nobis resident. That's Latin. By the way, when I was wrongfully detained, I started learning Latin. Right, I started because there was as I said, Montgomery County Detention Center or whatever, deals. They have all these books available, right? You could get any book you wanted. So I got a book, because I was also researching my case on my own, apart from reading. So I did a lot of reading. There's a legal library that you have. You get a tablet. So I was reading cases, and I decided to start learning Latin. I also started to learn Spanish. My Spanish was becoming very good because at the time, various times they kept giving me Spanish cellmates, right? One day I'll tell my story and get into it. And so I started learning Spanish. There was a guy, I had a cellmate who could not speak any English, right? And I couldn't speak Spanish. I had to start learning Spanish. So every time he would ask me, ¿Qué hora es? ¿Qué hora es? Means what's the time? So I had to be able to answer. So I knew how to be able to count everything. I had to be learning. And, comida, food, I had to start learning things like that. So I started to learn conversational Spanish. There was a lot of things that was going on, and I was saying how when I first was first placed wrongfully again. I'll tell my story. When I was first wrongfully detained, it was majority black, right? But by the time beginning of this year, the demographics in the detention center was now changing. We were now seeing lots of Spanish people, lots of people from Venezuela, of course, with the ICE raids. They were picking a lot of people up, and you just see a lot of unconstitutional things that are going on in our country. And so, déjeme salir, let me out, so I started learning Spanish, and importantly, anyway, I was saying that I started learning Latin. I was learning Latin through there's a Latin dictionary of phrases and things like that. I started learning Latin. So, que coram nobis resident, que coram nobis resident. It means which things remain present, which things remain in our presence, right? Que coram nobis resident. So the Korematsu and the dreadful Korematsu law was voided. It was vacated through a writ of coram nobis. Again, it's que. The full phrase is que coram nobis resident, right? Which things remain, in our presence, right? Which things remain in our presence. So it's saying that so coram nobis. The short is coram nobis is when it's also called a writ of error when there's a fundamental error in an earlier decision where upon discovery of information that was not in the records at the time of the rendering of the decision. And of course, if the information had been present in the records, the court would not have rendered the same decision. So it's like a fundamental error in the decision because of lack of information that was not there at the time. So later on, it was found out that the Solicitor General at the time, who handled the case, his name was Charles Fahey, he had actually suppressed evidence. In fact, around in 2011, the acting Solicitor General, Neil Katyal, had said he denounced the Solicitor General as, he said that he committed prosecutorial misconduct by suppressing evidence. So there was evidence from the Office of Naval Intelligence called the Ringo Report that said, that there was no evidence that the Japanese Americans were actually loyal. There was no risk of espionage or sabotage amongst Japanese Americans. So it was needless, it was not necessary to actually place them in internment camps. Again, So the courts had the opportunity to void, to say, well, that the executive order 1966 and the placing, which allowed military commanders to create exclusion zones and uh, create these concentration camps that basically imprisoned Japanese Americans, were unconstitutional, but they didn't. And they had the review process. Now, Hugo Black, the court claimed they used strict scrutiny. Again, these three judicial reviews, I'm just going to mention two so I don't confuse us. Judicial review is the process where the court, the mechanism whereby the court sees, they analyze if a law is constitutional or not. Strict scrutiny is the most severe, right? It's the most severe, so it's called strict scrutiny. And it's it places the burden of proof on the government, so it has a presumption of unconstitutionality, saying that this law is unconstitutional because it affects the fundamental rights of Americans. Fundamental rights, again, that deals with our liberty, freedom of speech, and things like that. And also a suspect classification. Suspect classification, that's a legal term that's saying that it deals with things like race. Suspect classification, when we're talking about racism, when we're talking about national origin, those are suspect classifications. So therefore, there's a rigorous standard. It's the most rigorous standard, strict scrutiny. And the government must show, the burden of proof is on the government. They must show a compelling government interest, right? A compelling government interest that's narrowly tailored, right? Narrowly tailored to achieve this goal, this compelling government interest, using the most least restrictive means, right? It has to be it's narrowly tailored. They're using the least restrictive means, right? So that's the standard that the court of Korematsu claimed that they used, but we see that it failed. Typically, if the court uses strict scrutiny as a standard to evaluate the constitutionality of a law, it almost always fails. It almost always says that, well, this law is unconstitutional. So, in fact, the Korematsu case was the first time that the courts used strict scrutiny as a standard. But this time, the court said that, irrationally, through flawed reasoning, the court claimed that, well, that the government passed strict scrutiny, right? And funny enough, the court actually used the precedent of, there was an earlier case, Gordon Hirabayashi's case, and so Hugo Black, the court said that they used the precedent of Hirabayashi. So Hirabayashi was during the time of the Second World War, and he also dealt with the issuance of the Executive Order 1966. But it dealt with this. In this time, Gordon Hirabayashi was violating a curfew. So there was the military command had issued a curfew restricting Japanese Americans, specifically Japanese Americans, to restricting them within certain hours, to be under curfew within certain hours. So there was a guy, Gordon Hirabayashi. He was a Japanese American born in America. Fred Korematsu was also born in America. So they were American citizens. Gordon Hirabayashi was actually a student at the University of Washington, and he wanted to he wanted to challenge the constitutionality of the law, right? So he was a student who was saying that, no, this is unconstitutional. So he deliberately violated the curfew, and he turned himself over to the FBI after he violated it. He went to court. He was trying to challenge it, that it violated his constitutional rights, that it was it was racially discriminatory because it targeted Japanese Americans, right? However, again, it was the Chief Justice then was Harlan Fiske Stone, and that's Harlan Fiske Stone, right? So the court at the time used the rational review basis, rational basis, right? Review standard. That's the least it has the minimum scrutiny. It's the least exacting, right? So for rational review standard, so you see a conflict, a contradiction, right, between the case of Hirabayashi and Korematsu, the subsequent case. Korematsu was decided in 1944. I think Hirabayashi was maybe 1943, but Korematsu case said it was using Hirabayashi as precedent. Now, Korematsu used strict scrutiny, which it should have used, right? But it should have failed using strict scrutiny because it was racist. It was using race, even though the justices through legal legerdemain were saying no, they didn't use race. That racism wasn't a factor. It was just a military expedient, right? Which the government, the military, were authorized to do to win a war. That was their argument, which wasn't an argument. But they were citing as precedent that, look, the law already exists, right? It's already been deemed constitutional through Hirabayashi, which used rational basis review. It shouldn't have used rational basis review. That's a Hirabayashi case. The Hirabayashi case should have used strict scrutiny because, again, when it deals with suspect classification, when we say suspect classification, we're dealing with issues that deal with race, right? Race, national origin. Japanese Americans were interned because of their Japanese ancestry, and we were at war with Japan. So they were the ones who were targeted, and there was a curfew. In the case of Hirabayashi, there was a curfew restricting their movement within certain hours, right? So the court should have used strict scrutiny, not rational basis. So rational basis is the least exacting. Rational basis, the burden of proof shifts from the government, and it goes to the individual that's challenging the law, right? The individual challenging the law now has a burden of proof. So in this case, it's presumed constitutional, and all that's required, the government, the government just needs to show that there's a legitimate, right? There's a rational basis. There's a rational relationship, right, between the legitimacy of the law, right? Between the that there's a legitimate reason, right? There's a legitimate reason. It's rational. There's a legitimate reason in the law, in the law, and a legitimate government reason. It's legitimate. There's a rational relationship between the law and a legitimate government interest, right? And it's the least it's the least exacting. It gives deference to the federal government. It gives deference to the government, whether it's federal or state. It gives deference to the government, to the legislative, to the lawmaking body, right? It gives deference to their judgment that, okay, hey, they do have a legitimate interest, and it's rational. It's rational, right? There's a rational basis, and it applies in instances of like if it deals with a social welfare issue, right? Economic regulation, right? So this was not a matter dealing with. It wasn't because of food stamps, right? This had to do with race, because the group was being targeted. They were being restricted based on people of Japanese ancestry specifically that were being restricted, that were under curfew. So this had to do with race. So the court did not reason properly. They didn't use proper legal reasoning. There was a flaw in the legal reasoning. They used rational basis review instead of strict scrutiny. Strict scrutiny deals with suspect classifications and fundamental rights. A suspect classification, as I mentioned, deals with racial discrimination, race, national origin, and in this case, it was Japanese Americans that were being targeted for restriction or for a violation of a right or a law that was restricting them, based on their Japanese ancestry. So that was based on a racial classification, right? And the subsequent court, Korematsu, they did use strict scrutiny, but they used it in a flawed manner. It failed. They did perform legal legerdemain. this video has gotten long. I'm going to do a subsequent video and I'm going to talk about the background and later on. By the way, Fred Korematsu, he since became a hero, and I'll discuss that later on in a subsequent video. My name is Olurotimi Osha. I like to talk about American presidents, and today I was just talking about a time Franklin D. Roosevelt used emergency powers during the Second World War, and the powers have the exercise of those powers have since been described as a stain on American jurisprudence, and it's been deemed unconstitutional since then. There was a case, Trump versus Hawaii, I think 2018. Chief Justice John Roberts, he from his opinion, his discussion, he deemed it unconstitutional. I also talk about color of law violations, pivoting on subordination of perjury and fraud on the court. Again, the courts in Montgomery County, superintended by Judge James Bonifant, has violated my constitutional rights, right, using fraudulent emergency. Using he was using a false incompetency to stand trial orders, right, in violation of my constitutional rights, right. I've been deemed I don't have a mental illness. There was no basis for him to order a competency to stand trial order. It was because it was also based on a fraudulently filed emergency evaluation petition. So there was fraud in the beginning, right? And the court was still continuing with these fraudulent practices based on a false police reports, and false accusations, and my rights were being violated. So the court was attempting to coerce me, violating my rights. And of course, what was going on was it was all done to actually obstruct justice, right? I'd filed Office of Special Counsel Equal Employment Opportunity complaints against people at work, which was my constitutional right to petition the government. And it looks like something fraudulent was now done, co-opting the courts in Montgomery County, co-opting Montgomery County Police. I was swatted. Swatting is a crime. And the Judge Bonifant has been sanctioning these fraudulent acts and violating my constitutional rights. Again, I continue to seek justice, and I'll keep you posted. Thank you.